Days after your accident, when you are still managing pain and paperwork and the shock of what happened, a form will arrive from the insurance company. It will come through a friendly email or be mentioned casually in a routine call. It will look standard. It will feel like one more item in the claims process you need to get through. And most people sign it the same day it arrives. That form is not a formality. It is the single most powerful document the insurance company will ever ask you to sign. It legally authorizes them to access your entire medical history, not just records related to your accident, but every doctor visit, every diagnosis, every prescription, every therapy session, and every prior injury from years before you were ever in that crash. One signature, in a moment of pain and distraction, can reduce your settlement by tens of thousands of dollars. And the insurance company is counting on the fact that you will not read what you are agreeing to. Welcome to Torts Truth. This is your decoded advocate. Before we go deeper, understand the foundation of what is actually happening when you file a personal injury claim. The company handling your case is not a neutral investigator. It is a financial institution managing its liability exposure. And the claims process is not designed to determine what you fairly deserve. It is engineered to minimize what they are required to pay. Within the first 72 hours after a serious accident, two parallel processes begin simultaneously. Your medical recovery is the one you are focused on entirely, and their investigation is the one running quietly in the background, while you are still trying to process what happened. The Broad Medical Authorization is the first major instrument deployed in that investigation. The form arrives early by design. You are overwhelmed. Your schedule is consumed by appointments and calls and financial anxiety. And what lands in your inbox looks like a routine administrative step. It is labeled something like authorization for release of medical information, and the language inside is written to sound completely procedural. But the scope inside that form reads, authorization for the release of all medical records including, but not limited to, records for physical conditions, mental and behavioral health, substance use history, prior injuries, and any other health-related information from any provider. The phrase any provider means every physician, every specialist, every emergency room, every chiropractor, every therapist, every urgent care clinic you have ever walked into. And without a date restriction, they can search as far back as records exist. This is not a targeted request for your accident-related treatment. This is a full access pass to your entire medical life. They are not gathering your records to process your claim fairly. They are gathering them to build a case that your injury is not as serious as you say it is. Here is the exact mechanism by which this destroys claims. And most accident victims never encounter this information until it is already too late. Personal injury law in the United States operates in part under a doctrine called comparative fault. This doctrine allows an insurance company to argue that your injury partially existed before the accident, or that prior medical conditions contributed to the severity of your current damage. And that argument legally reduces what they are required to pay you. Here is what that looks like in reality. You were injured in a rear-end collision. Your neck and lower back are damaged. Your treatment is documented. Your pain is genuine. And your claim appears straightforward. But 4 years before your accident, you saw a physical therapist twice for mild back tension after long hours at work. It resolved completely. You moved on, and you never thought about it again. This is not an edge case. This is a documented and widely used defense called the pre-existing condition defense. And it is applied across every state in this country by adjusters who are specifically trained to find it, use it, and reduce your claim with it. The form they sent you was written specifically to make that defense possible. And it was delivered before you even knew a defense was being constructed against you. There is a second layer to this trap that almost nobody discusses, and it involves mental health records after a serious accident. Anxiety, difficulty sleeping, depression, and post-traumatic stress are clinically documented responses to trauma. They are also compensable under most personal injury frameworks, meaning if you experience genuine psychological harm caused by someone else's negligence, you are legally entitled to be paid for that harm. But when you sign a broad authorization, your therapy notes, your psychiatric evaluations, your counseling records, all of it becomes accessible to the insurer. And defense teams have used prior mental health history to argue that a claimant's reported emotional suffering predates the incident. that their perception of pain is magnified by pre-existing psychological factors, or that their distress has no direct causal relationship to the accident at all. Your most private records become evidence in a financial negotiation you did not know had already begun. Your right to psychological recovery is real, and so is your right to protect that privacy from being quietly turned against you. Now, refusing to provide any records is not the answer. The insurer has a legitimate right to documentation that is relevant to your specific claim, and the word relevant is exactly where your protection lives. A properly constructed medical authorization specifies the exact injury sites directly related to your claim, the date range beginning from the date of your accident only, the specific providers currently treating those injuries, and an explicit written exclusion of prior medical history, mental health records, and any conditions unrelated to the documented accident. This is called a targeted medical release. It satisfies the insurer's legitimate documentation needs while protecting every piece of your history that has no bearing on the claim at hand. And it is standard practice when a personal injury attorney manages the disclosure process on your behalf. Without representation, you receive their form, written entirely in their financial interest, and most people sign it because they do not know that negotiating the scope of a medical release is even permitted. The Insurance Research Council has consistently documented that represented accident victims receive settlements averaging 3 to 4 times higher than those who handle claims alone. Even after deducting attorney fees, a substantial portion of that gap exists because represented victims do not sign broad authorizations, do not surrender their full medical histories, and do not accept initial offers before documentation is complete. The information gap between a trained claims adjuster who has worked thousands of cases and an injured person managing their recovery alone is not a minor difference in knowledge. It is a structural advantage that the insurance industry has spent decades deliberately building. If an adjuster contacts you requesting a signed medical release, your response is direct and immediate. I am reviewing all documentation with legal counsel before signing anything related to this claim. You do not need an attorney retained to say that sentence. What it communicates is that you understand the process, and it changes the dynamic of every conversation that follows. Most personal injury attorneys offer free initial consultations and work entirely on contingency, meaning they receive no payment unless your case resolves in your favor. Your medical history belongs to you. Your suffering is real, and no document sent by an opposing financial institution holds any claim to information beyond what directly and specifically relates to your documented injuries. If you missed our last video on how insurance adjusters are trained from day one to manage your claim before you even understand what is at stake, the link is in the description below. Watch it after this one. The form they sent you was not administrative paperwork. It was a legal instrument drafted by professionals whose sole objective is to pay you as little as the law requires. Now you know exactly what it is, and that knowledge may be the single most valuable thing you carry out of this entire claims process.